Okay, good morning, everybody. I'd like to call the meeting to order and have everybody stand for the flag, please. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. I'd like to take note that all the commissioners are here and present today. Are there going to be any agenda changes?
No.
Okay, then we'll move right into public comment for anything not on the agenda today.
Good morning, members of the commission. Bill McManus, Committee to Ban Commercial Cultivation. I come to you today. I'm sure you'll know everything that I'm going to relate to you. I just want to reemphasize it and carry the message from the committee and citizens forward to you. The Board of Supervisors has punted the regulation ball back to the Planning Commission. We don't know if there's any requirement for the Planning Commission to take this up. We've been told no. We're hoping that the Planning Commission does not take it up and instead tell the Board of Supervisors to deal with their plan and get it done. Right now, the plan that's coming before, we call it the Tofanelli regulatory scheme. It's a series of regulations, some tougher than the urgency ordinance, some added in, some are just, I don't know what they are. There appears to be a huge problem on the horizon, and I'm not a lawyer, but on January 2nd, Prop 64 will take effect. On January 2nd, everyone in this county who has a license, and presumably anyone who has a license or an application, will be able to apply for a state license. In 1795.030, I believe it's paragraph D in the last sentence, even the planning director will be giving the state a letter saying that these people don't have their county license through no fault of their own. It doesn't reflect on their inability to comply, things like that. So if we don't get something passed, and this is just the information I have, by the end of November, the effective date of that permanent ordinance will not be until the end of the year. If it slips by one day, now what happens? We'll be in conflict with the state. So if you think that there's going to be a lot of lawsuits and legal problems doing it the right way, wait until you start getting into conflicting law between state and county. First of all, our absence of something and the presence of a state regulation, which is Prop 64. Of course, we've been saying all along that the easiest way, the most complete way, the most bulletproof way of dealing with this problem is to ban it. You don't need an EIR. You don't have to worry about, well, you'll get some lawsuits, but you'll be on firm ground. You won't be in conflict with the state having to decide who has jurisdiction over which issue. And to take 300 or more applications that are currently in the pipeline on January 2nd, those are going to be 300 state licenses. And then the Tofanelli regulatory scheme falls apart because you put a cap of 50 on it. Now, how you have government pick and choose winners and losers, I don't know. I think that is an equal protection issue. I think it's in dangerous territory, and but that's what they want to do. The other thing is limiting, getting it out of the neighborhoods, putting it in A1, AP, or GF. No one has thought about the tremendous amount of unclassified property there is in this county and how anxious the county normally is to have it classified as something. So we'll be getting a flood of zoning changes from unclassified to A1 or GF or something else. No one has thought about that. So that further expands the opportunities for growing until pretty soon everyone is growing. And the only other question I would have, and I know you guys don't answer questions here, is that we've been going at this for so long. It seems as though there's almost a conspiracy of delay going on here. It's been almost a year since the board said, we want to do a ban. We're still not there yet. It's been EIRs, draft EIRs, responses, filing, getting all the information back out that the people sent in and answering their questions. It goes on and on and on. And this county has definitely shown a lack of will to do anything about this. Now, I think someone's going to have to start doing something about it. You've got a hard deadline coming up. And I don't know how the dates are going to overlap, but also like to know how many licenses have expired and been renewed, and has their renewal payment been received, and how much money has the county received for licenses that were issued over a year ago. I think my time is up. Thank you.
Hold on. I just have a quick question, if you don't mind. You had said something about the licenses, what's going to happen with the 1 year there, that nothing will happen in that 1 year time period. What are you referencing in that?
I'm sorry.
You talked about a 1 year lapse. If we're not in place by January 2nd, there will be a 1 year lapse for all of those that have registered. What are you talking about? I don't understand.
No, I didn't mean to say a 1 year lapse. What I'm saying is that on January 2nd, Prop 64 takes effect.
Correct.
Okay.
We're well aware of that one.
Are we close to your question?
No. Back in your comments, you talked about a 1 year issue. You said if we don't have this in place.
Oh, the only time I refer to 1 year is that it's been almost a year since this process started. And we're no closer to the end.
No, it was something different. Did anybody else hear that?
That's the only 1 year, I think.
Okay, well then I'm mistaken. I apologize.
Well, no, if you have a question, I don't want to be misunderstood.
Okay, no, we're well aware of the January 2nd timeline. We sent it back to the supervisors with 2 issues to make sure we covered our bases here. It is coming back. We are going to hear it on November 29th, and I'm hoping that we get it done as much as you are.
So that means that it won't go back to the board for a board vote until sometime in December.
Possibly.
And that means that even if they vote on it in December, there's a 30-day period after an ordinance is passed before it becomes
Our
effective.
urgency ordinance is in effect until February 14th.
I don't think that's going to cover you.
Well, we're going to do the best we
Because
can.
if you pass anything, the urgency ordinance vaporizes. So either that or you'll have to wait until after the urgency ordinance expires to do something, or make it concurrent on the same day. So any ordinance will erase the urgency ordinance.
Thank you.
That's my understanding.
Okay. Is there any other public comment? Okay. Okay, if there's no further public comment, and there's no consent agenda today, so we will go into our public hearings. Item number 1, looks like we have Miguel presenting. Miguel, would you like to take that up?
Sure thing. Good morning to the Planning Commission. This is Miguel with the Calaveras County Planning Department. Today I'm here to present Appeal 2016-893.
The mic's tilted that way. There, perfect.
All right, so jumping in, this is Appeal 2016-893. Just a brief little context. The cultivation site or the project location is at 1211 Pony Way, Angels Camp. Essentially what happened is on September 7, 2016, the appellant submitted a NOI for a Tier 3 to the Water Board. However, they did not include a site management plan. On January 25th of 2017, the Water Board mailed a letter to the appellant indicating that they need to submit the site management plan in order for their application to continue. The appellant did not respond. On July 11th of this year, the Water Board sent out a second notice to the appellant indicating that they had 30 days to comply with the Water Board and submit the site management plan. On September 5th, 2017, planning staff was in contact with the Water Board. The Water Board indicated that the appellant had not yet submitted the required documentation as of September 5th. And that's about it for my presentation.
Okay, thank you. I'm going to have the appellant's representative come up. I just want to state that you get a 15-minute presentation time period. Just want to make sure that goes on the record. And if you're giving more further new information, then we would allow you to go on. But if it's the same old input, we're going to go. Time up.
Understood.
Okay, thank you.
Good morning, Commissioners, staff, council, and the rest of the fine people from Calaveras County here behind me. I went over 15 minutes last time, so I'm intent on being succinct and quick today. And I think it's going to be easy to do. Have no dispute with Mr. Contreras' description of the facts. But I submitted a brief. Was everyone able to take a look at that, get a chance to review that?
Yeah, but apparently it was submitted like 2 hours late to the planning department.
It was, yeah, I guess. I brought copies, I guess, around 6:30 p.m. So it was about an hour and a half late Monday evening. And I do apologize. If I may enter the well, I do have copies.
Would you give them to Annette, please? Because I would like to see it.
How many?
I have one.
You have one?
Anyone else? Care of a copy? They're up here, change your mind. Yeah, council.
There you go, as many copies as you want.
If I may, while you review that, I can summarize. I think it's also, if anybody cares for a copy, I know this is on the internet. They can email me rather than, you can always, I'm sure you can contact the county, but if you want to save them some trouble, jcm@archernorris.com. Be happy to email anyone a copy also. So we're talking about one section of the urgency ordinance 1795-165N4, basically calling for compliance with the water board's regulation. Applicants are required to either submit an NOI at the time of entry of their registration, or if not, by September 7th of 2016, a complete application. So what the registrant, and I am here on behalf of the registrant, Mr. Robert Smoot, turned in the NOI September 7th. Prior to that, he hired and retained a technical consultant, Sam Davey. He's a water expert. His qualifications are listed in the brief you have before you. And I think right off the bat, that is the best environmental practices dictate that you retain technical consultants. I'm not a water expert. Mr. Smoot is not a water expert. So what did he do? He hired one. And in that, by doing so, why that is the best environmental practice? Because the end result would be the most effective and efficient protection of the environment. The water, and I know the drafters of the UO are here from what I understand, so they would know better than I what the intent of this particular provision is, but it appears to me that in short, it's to protect the water, it's to protect the environment, and no better way to do that rather than relying on his lay knowledge. He retained a technical expert. So around June of 2016, Mr. Smoot retained Sam Davey, a water expert with experience in the field going back over a decade. Mr. Davey commenced preparing the complete application with the Central Valley Regional Water Quality Control Board. Was in contact with the gentleman down there who at the time was kind of managing, I think, the cannabis department, Trey Sherrill, whom Mr. Davey had a prior relationship with just through work in the industry. A lot of telephone calls, email correspondence. So the work ensued. Mr. Sherrill and Mr. Davey had communications that in order to ease facilitation of this application, all required and necessary documents, I believe it was for Tier 3, would be submitted together. There's emails to that effect in the brief. There were a lot of telephone conversations also. I think Mr. Davey was pretty diligent in working on this. And I think important to understand that, as we all know, this process has been delayed at every department and stage, whether it's planning, water boards, the attorneys, all the technical consultants, the geotechs, the hydrotechs. If you call somebody today and say, hey, I need to have you, a consultant, have you come out here and draw me a site plan for a grading permit I got to get, they'll tell you, how does March sound, right? That's the nature of the backlog here. And I think it's shown a little bit with the water board. But nonetheless, Mr. Davey was working diligently to get this application done for Mr. Smoot. It's his obligation to do that. Mr. Smoot's relying on him. So January 25th comes around. That letter comes out. Mr. Smoot gets it from the water board saying, hey, you still need this site management plan. Rob calls Sam. Sam, what's the deal? Can you help me out? What's going on? Sam calls Trey Sherrill again. Hey, Trey, what's going on? We have this agreement. We'll get you. We're working on the site management plan, Form 1A, Form 1B, a couple other documents in there that slipped my mind but are mentioned in the brief. So they continue to work on that. And I know Mr. Davey is busy. I know Mr. Sherrill down there was busy. At some point, early to mid 2017, Trey Sherrill leaves the water board. I don't know why. I probably would have as well. But I hope it wasn't for any illness, but rather a different opportunity. Nonetheless, another gentleman takes over, Michael Parker. Mr. Davey, who's here as well, picks up the dialogue with Mr. Parker, emails in there that between Mr. Parker and Mr. Davey. Again, organically working to get this all done. It's fine with Michael Parker. Submit them all together. Thank you for contacting me. The process goes on. It's my understanding that all the documents then were submitted around August 1st, including the site management plan. September 5th, planning goes ahead and calls the water board, and water board says, no, we still don't have that site management plan. Mr. Davey emails Michael Parker, hey, Mr. Parker, I realize, I thought you said I could submit them all together. If you don't have it, let me know, I'll get them to you. So ends up, he does have it now. Water board does have the site management plan. Whether they had received it prior to September 22nd remains to be seen, but they do have it. And it just, to some extent, I think it may be a situation where the right hand and the left hand aren't communicating to an extent at the water board. Here we have Trey Sherrill and Michael Parker working with Mr. Davey saying, okay, yes, get those to me all together when you can. We're still processing your application. Meanwhile, the senior geologist is also doing his job reviewing, hey, no SMP, I'm going to send this letter on January 25th, sends it out. And then the next one, shortly thereafter, calling for compliance within 30 days. So, again, Mr. Smoot, and I lay it out in the brief a little more thoroughly, really did what has to be considered the best practices in what's the end goal? Let's protect the environment. Let's protect the water. How is that done? Well, that's done by hiring an expert who can tell you how to do that, how to orchestrate that, and that's what Mr. Smoot did. He relied on his expert to take care of this portion of his application. I think his technical consultant did a great job. Was communicative. Wasn't didn't run out on him without communicating to the board and to Mr. Smoot. So. And in my brief, I say also, I'm not calling upon any precedent decisions of the commission here. I think you guys are in the best position to know what you've done in the past. We ask you to call upon that experience. But as far as a subjective analysis of this particular instance, we'd ask that you don't adopt the planning department's resolution denying, but rather grant our appeal, so that Mr. Smoot, who is now in compliance with N4, can continue, and that planning can continue the review of his application, because he has shown an intent and an actual conduct that would best protect the environment. And if you have questions, Mr. Smoot is here, as Mr. Davey as well. But that would conclude my presentation 3 minutes early, so I don't run on here.
I
Thank you, guys.
definitely have questions, as I'm sure others do. You want to go first?
Yes, I'm not sure who's in the best position to answer these questions, so I'll ask them. And it may be Mr. Davey. The first question is, prior to September 7th of 2016, did you have any discussions with anybody at the Water Board regarding when the SMP had to be submitted?
Casual conversations, of which we had gone down, I believe this September 7th is actually, correction would be of when the county had received it. I believe Rob would have a receipt of the check being delivered to the state on the June 30th of 2016, as was required with the initial application process. Knowing that we were shortly behind there was just some general conversations with Mr. Sherrill that said, don't worry, we're overwhelmed, as so is the county, so work on it at your rate, and we'll get back to you if we're dragging our feet.
And that was prior to September 7th, those conversations? Because they don't show up in the timeline put forth in the brief.
Those were just general phone conversations post June 30th, because we did not have the SMP in on the June 30th with the NOI.
Okay, when did you start working on the SMP?
It would probably be in the fall of 2016 when the initial Form 1A was being completed.
So it would have been after September 7th?
Yes, sir.
Okay, the form, the NOI form for Tier 3 says, and this is underlined, a site management plan describing practices that you will implement on the site to minimize impacts to surface and groundwaters must be attached to this NOI. Was there any discussion with Mr. Sherrill about why it is, since this is on the actual NOI form, he's telling you that you don't have to do it?
He gave me a verbal confirmation that it was okay to be delayed.
Okay, do you have any emails or notes or writings of any of those conversations prior to September 7th in which Mr. Sherrill assured you that you didn't have to submit the SMP by September 7th?
No, sir, just because I had had that rapport with Trey.
With respect to any of these discussions with Mr. Sherrill on September 7th, 2016, or thereafter, and apart from the emails that we have, do you have any notes or writings regarding those conversations?
No, sir. I would maybe be able to come up with some emails if I dug way back, but to my knowledge, no notes on a conversation.
I understand from the emails that you had advised the water board that you would be submitting all of these documents at the same time, correct?
Yes, sir. The Form 1A is to be completed in November, and the Form 1B would be completed in July, of which they would both be submitted together as one packet. The Form 1A is to be completed, but not necessarily mailed out in November. They come together as one packet in the end of July.
For those of us who don't know these rules at all, can you tell us what a Form 1A is?
Form 1A would be called your Implementation Effectiveness Monitoring, which would basically just be a checklist of your BMPs, and it's a general statement of here's the practices I'm going to be applying to my project. Then you wait out the winter, monitor your project. Form 1B would be your effectiveness monitoring of where you would fault yourself for places you need to improve, additional findings that you may have to be adjusted the following year. And so those two forms get submitted together at that time.
You mentioned November for submitting Form 1A, is that correct?
No, November for submitting them both. 1A has to be completed, November 28th of this year, Form 1As are due again for everybody. Those packets don't go mailed out until the end of July, attached with Form 1B. So they're both mailed together annually, just as one.
Okay, so if you go back to 2016, when was the time under the rules that Form 1A should have been submitted?
Form 1A would never have been submitted in 2016. Only completed and held on site. From the end of November on, that form just needed to be completed, filled out, and held on site.
Okay, so for the year 2016, was there a time in which Form 1A should be submitted?
No, sir.
So when were you supposed to submit Form 1A?
Form 1A and 1B, of July of this year would be 1A of last year and 1B of this year. So it would be a water year 2016-17.
Okay, so if you had advised the water board that you would be submitting the SMP together with Form 1A, then the time to have done that for 2016 would have been July of 2017?
Yes, sir.
Okay, were those submitted in July of 2017?
Yes, sir. August 1st of 17 was sent out.
Okay, we have attached to the brief a copy of the site management plan dated August 1st, 2017.
Yes, sir.
What I don't have is anything from the water board saying they got it, or anything in writing from you saying, here it is.
Okay,
Do those documents exist?
I do believe that Michael Parker had notified the Planning Commission that they had received the SMP and that he could proceed following the decision of this meeting.
Well, according to the staff report on September 5th of this year, 2017, they were advised by the water board that the water board had not received the SMP.
Yes,
So do you have any
and I'm
explanation?
not sure of that oversight, and so then there was the immediate call back and say what's going on, because they did have 1A and 1B in their possession. So then I had resent it, and then following that conversation, Michael had informed me that he did let the planning department know that he has received the SMP.
Go ahead, I'd like to hear you.
All right, so this isn't my project. I'm taking it over for Paul.
Okay.
I was reading Paul's staff report, and one of the sentences reads that the water board has confirmed that they have received the documentation needed, as stated by the appellant and his attorney. It's emailed that was actually addressed to me, just because I'm the person that Michael Parker emails to, and I pass it on to Paul, seeing how it was his project. I made copies for the Planning Commission and for the appellant and his attorney to look over.
Okay, thank you.
The brief under date of September 22nd, 2017, refers to an emails attached as Exhibit B regarding the discussions referenced there. Our packet didn't have an email dated September 22nd, 2017. Is there one?
I think I took that out of the staff report, page 2, down at the end of the second paragraph.
Could you speak in the mic, please?
I'm sorry. So that date is September 22nd. I extracted from the staff report on page 2 that the CVRW QCB informed planning department that the appellant did submit the required documents on September 22nd.
Probably came in this September 20th. Emailing you in regards, it probably was attached there, and then I followed up right away in hoping that he had received it.
Okay, well, the confusion is the brief refers to emails attached as Exhibit B when you were actually meant to refer to the staff report for that date.
Yes, that must be
Okay.
too.
I got it.
You're right, that is my error. I did extract it from the staff report and then referenced Exhibit B, which actually shows September 20th as the date of communication.
During this time frame from September 7th up until the denial letter came out, did you have any communications with the planning department about what was going on with the water board?
No, sir, my association with any project would be strictly with state. My own judgment was to stay out of county issues and to handle things as the state would instruct me to do. So I strictly wanted to keep my relationship with the Water Quality Control Board at the state, and that was the extent that I would offer my services.
Okay. I don't have anything further at this time.
Well, I'd pick that up right there. In Mr. Melinelli, in referring to the right hand not letting the left hand know what was going on, what we seem to have here is this lack of communication with the planning department. Planning department, its denial was based on what it had received from the water board, which was 2 denials. I agree with you that we need to keep to treat applicants with an equal level of scrutiny. And just last week, and I'm subject to correction here, but we had a 2016-943 where the applicant had submitted a Tier 2 application to the water board, and by September 7th, that, as my understanding, it would have been complete if he had been accurate in determining it was Tier 2. He was denied, well, the water board sent out a notice of incomplete application saying, no, this should be Tier 3. He communicated with the water board, with Trey Sherrill, and was being led along. And the next thing the planning department knew was they got a second notice of incomplete, and they denied. And after that, the planning department did, in that case, well, after that, he did supply an application, a complete Tier 3 application. The water board then did notify, and this was all after the denial, the same sort of notification that we just got on your case, and that the water board was ready to go ahead if we granted the appeal, and we did not grant the appeal. And if anything, to me, this last week's case was stronger in that the September 7th deadline was met to the extent the applicant thought it could be by submitting an application for Tier 2, and it was on that basis that it was denied. So I have a hard time here. I think if your client had kept in touch with the planning department, they could have clarified things with the water board as time went along when they were receiving these denials. But I don't see how we can distinguish this case from last week's.
Well, thank you. And I'll take your word for that.
Yeah,
I
and
wouldn't
as I
try
say,
to
I-
distinguish it. I have no knowledge of that, but I
Right.
appreciate that. I think, speaking here, it's really imperative that the commission give due consideration to the difficulty in this new process at the state level, and not to penalize applicants, registrants who truly are operating in good faith and acting at the best environmental practices. Registrants must be allowed to rely upon their technical professionals in order to create a regulatory system that works to protect the environment, public health, safety, and welfare, where laypersons like this registrant and the one you mentioned earlier maybe can utilize and rely on environmental technical experts during the application process in order to ensure that these environmental and social protections are realized. It's absolutely imperative, and I think we've seen how that's difficult with all these moving parts, but the underlying intent to protect Calaveras County's resources and people absolutely must be considered, and really the best way for these applicants to do that is to rely on technical experts, and I
No,
submit
I
to
don't
you
think,
that
I don't think
you did.
anybody would dispute that, and I certainly agree with you that the idea is to protect the environment. The problem I see, I don't see how this case can be distinguished favorably. You know, the last week's case actually had, I think, better facts for the applicant than this. But I'm subject to discussion with the rest of the commissioners. Perhaps I've missed something there.
Thank you. Sure.
But I also wanted to point out that we do have these procedures for the submission of papers, and I really believe you should look at those just the way you look at deadlines set by courts. I mean, it's subject to our discretion whether we consider your brief or not. I actually read your brief and considered it. That was before I realized that this had been submitted late. But for future reference, I think that's something you really have to keep in mind.
You're absolutely right, and I'm humiliated that it was an hour and a half late. I'll tell you straight. I'm not going to tell you why it was. It was a comedy of errors on my end trying to facilitate getting that. I was working remotely, but so, yep, I don't anticipate doing that again. Don't want to do that again. Speaking quickly to deadlines, I know that the September 7th date, there's another deadline, you know, in 1795, 165N4, and I know that, again, different cases for different registrants, but this board has exercised its discretion in one of my prior appeals where that September 7th date was, the board acted with its discretion to, I wouldn't say waive that date, but make an exception, and that was a narrow exception based on a late filing past that date. So,
Yeah, and I'm not saying that we have a strict September 7th, that we have read the ordinance as not requiring full compliance, and such as this case last week where they filed for Tier 2 and it ended up being Tier 3. There, I think if there had been communication with the planning department and then resulting coordination with the water board, we probably wouldn't have had the problem. And that might well have been the case in this current case. But applicants should realize that the county's definitely a player here, and they're the ones that have the license granting abilities. And if there's some hang up with the water board as far as the timing goes and getting things done and this sort of thing, the applicant needs to keep in touch with the planning department to let the planning department. It's very hard for the planning department to be relying upon what it's receiving from the water board, which is 2 notices of denial. That's what they had, and not deny it.
thank you, Commissioner. Can I ask again when the date of that other registration appeal that you mentioned?
It was last Thursday. It's 2016-943. And while you're at it, you might also look at 2016-545, which we also heard last week.
Well, I hope, I'd prefer not to have to, other than just for, educational purposes going forward.
Sure, but if I completely misstated it, why, have at it.
I'm sure you didn't.
I have a follow-up question or two. I have a question
Yes, Commissioner.
following up on Commissioner Wooster's comments and questions about Forms 1A and 1B. Is that part of the SMP, those 2 forms, or is that separate?
No, sir, that is separate from the SMP because even a Tier 2
So the-
cultivation site would be required to do that as well.
So the SMP that's required by the Notice of Intent form in bold, underlined letters, words, is the 9-page site management plan that you submitted, the date on it, August 1st of this year, correct?
Yes, sir, which was requested to be turned in with the Form 1A and 1B that needed to be completed by July 30th. Or 1B needed to be completed by July 30th
and
and
your-
attached with 1A.
In your support of that theory is your discussions with Trey Sherrill at some point in time.
Michael Parker had informed me that it was going to be okay submit 1A and 1B together with the SMP following that July 30th of the 1B needing to be completed.
Michael Parker didn't get involved until sometime this year.
Right after the first notice to Mr. Smoot, I believe it was.
Right. I see no emails or records of discussions in the period from September 7th, 16 until June of this year. Am I missing something? I think that's the time period you said
It's
you talked with Trey Sherrill and maybe Michael Parker as well.
I had only spoken with Michael Parker this year prior to the 1A and 1B needing to be returned.
I'm talking about, perhaps the attorney could answer. Looking for records, written records of these emails or communications supporting the theory that either Trey Sherrill or Michael Parker has said it's okay to submit these things late.
Right. So the exhibit containing the emails or the extent of the emails I have, I also point out in the brief that predominantly, I think the communication which Mr. Davies is here to testify, so that's the evidence, would be in the form of oral testimony.
And Mr.
But
Davey also said, I
yeah.
might have emails if I dug way back. And today's
I
the
heard him
hearing,
say
today's the trial.
Right.
And if I'm not mistaken, if you don't have evidence today and you do appeal this to the Board of Supervisors, I don't believe you're allowed to bring in new evidence after this point.
I mean, the supervisors can determine, the supervisors can, if he brings in new evidence, the supervisors can determine if it's important enough that it might change their minds, and if they think it's important enough, they can bring it back to the Planning Commission to review the new evidence only.
Can you tell me why the SMP wasn't done before September 7th? This 9-page thing, it's typed up, doesn't seem to have any forms. It's got a picture of the site plan. Why couldn't that have been done by September 7th of 16?
Because due to workload and talking to them, we were given the verbal that it was okay to proceed, at our time frame.
I believe you said that verbal was later, though, after September 7th.
The exact date of which it was due, speaking with Michael Parker, that was confirmed later. Trey Sherrill's initial stuff was not to worry about it. We're working at a pace that we can work at, so you're fine.
Commissioner, I mean, that really illustrates the point, 2 points, that the tremendous workloads that these technical consultants were under, to some extent prejudices their client. And I don't want to lay blame on the consultant here today, but that illustrates that the second point is that these registrants really have to rely on their technical consultants in these technical fields. And that's what Mr. Smoot did. And it comes to light that there may have been, or there should have been more communication with planning, but, and that could be true. I think that, again, is a situation where the applicant is relying on his consultant to do that communication. We just heard that the consultant had a different idea. There was a breakdown in communication there. The consultant was dealing only with the state, but when the registrant got the letter from the state, he went to, it's from the water board, he went to his water guy. And unfortunately, there was no communication here, so there was a slight breakdown. But I just want to, again, illustrate how important it is that these registrants hire technical consultants, and they really rely on them, and they shouldn't be penalized. And I pointed out prior that there's a rule of law, I think it's 473C. I always get that mixed up with the summary judgment statute, but for inadvertent error or mistake, basically where a professional lawyer does something that hurts the client, a client should never be penalized. I'll be the first to fall on my sword if I do something that damages my own client, and I think that same standard should be held where a professional, and I'm not saying he did, he's got a heavy workload, he was in communication getting some positive feedback from the water board, but where a professional lets down his client, that client shouldn't be penalized.
But here we're not, we're presumably, the client was being kept informed of denials from the water board. I mean, they were probably addressed to the client.
And he got them, and he gave them right, I mean,
That's
like
the,
that.
but there should have been a glimmer there that, well, wait a minute, this is a license pending with the county of Calaveras, and I better keep them informed that this is going on. And that's no technical expertise that we're talking about. It's just
Agreed.
common sense that that there's this sword hanging over his head, and if the planning department is receiving notices of denial here and then another one 6 months later, the storm's going to be brewing.
I agree to the extent that he ought to be vigilant and active, and when he sees that letter from the water board, which I want to look at very quickly, he went to his water guy, and I think he did rely, and he did have that glimmer, and relied on his water guy, his technical consultant, to address that. And that's where the breakdown was.
But there's nothing water technicalities, no water technicalities involved in is the planning department going to do anything about this? That's my point.
Okay.
We can go back and forth.
No, I know,
And by
but
the way,
it's the same as if when he gets a denial, he calls the lawyer. When he gets water, he calls water. When he gets something related to grading permit, he calls the geotech. I agree there needs to be communication amongst the state and the county and all these agencies, and that's what we're working through. It's been a long, strange process, and it really is it's coming together. But I think there needs to be consideration to how everyone is just still learning, the state and the county and the applicants and the techs, technical consultants. They're doing their best, and I think this registrant certainly has been doing his best.
And by the way, we are well aware of the seriousness of what's at stake here.
Of course.
I'm not implying that you're implying that we're not, but it's a very important thing that we're dealing with, and it is important to us that we do it consistently amongst the various applicants. You are aware of how you get access to the videos of these commission meetings, are you not?
YouTube.
Oh, okay, I wasn't aware.
I think they're on YouTube. Shortly after, you can watch them live, from what I understand, yeah, and then YouTube.
Okay.
Okay, so I just have a couple things I want to address. I get so irritated when people come up here and they talk about how deficient the county is in doing their job because of overload. We've hired extra people to handle it. I think our county has done an amazing job. I don't place the blame on the county. I place the blame on the people that are applying for these applications that were operating in illegal manners. They didn't have building permits. They didn't have electrical permits. They put in wells illegally. They graded our land illegally. They caused the overwhelming situation, not our county. So, I'm not going to take it anymore. I'm tired of my county, our staff being slapped when they didn't cause this problem. I think that every single one of these people at this county, from the building department to public works to the planning department to the environmental health department, deserve the biggest thank you. That staff has worked hard these last 2 years. This situation has caused delays in this county that I am just frustrated with, because we have a general plan lingering out there. Things like that get pushed back. So don't come before me and tell me your client didn't do what they were supposed to do because our county wasn't doing their job.
I didn't do that.
No, you did.
I
You
understand.
originally
That's not
started
me.
out stating
Never do
things
that.
like that, but that's beside the point.
I would never do that.
At this
And
point,
you've heard me before.
I have heard you before. Thank you, because it's important to me. But we do have the state, we do have the county, and when we say the county and the state aren't communicating with each other, I look at this appeal, and there's 2 letters from the state communicating with our county saying the job's not done. What are we supposed to do with that? Send out a denial. There was 2 warnings sent to your client that was received by our county. That's communication between state and county right there. 2 letters, job's not done. At that point in time, somebody better pick up the phone and call the planning department and say, the job is done, the state's wrong, here it is. But you couldn't do that because we didn't get a letter till September 22nd, which is far after that date. I'm struggling with all of this because a lot of this problems, some of it is communication, but I think it's lack of communication between the applicant communicating with the county and staying on top of it when the state sends out a letter. That's important. Does any of the other commissioners have questions?
I have to respond because I absolutely do not, I didn't place any blame on the county here, and I never would.
You said they're overwhelmed and
They
overloaded
are.
and they're behind
They
and blah,
are.
blah, blah.
They
That's
are.
what I'm referencing.
Everyone is. And that's not a slight, and that's not a shame on the county. By quite the contrary. It's just a state of real fact, and I have tremendous respect for this county that has taken that innovative and progressive step to say we're going to do this, and it's been extremely difficult. It's a model for every other city and county in the
It is.
state,
I
and
agree.
it's commendable. But the fact is, it's new and it's been difficult. So by no means did I intend to slight the county, the staff, the commission, the departments, because that's not what we're here to do. We commend them and proud, quite frankly, of the job that they've done. But I really was just recognizing the difficulty that everyone has faced as a new regulated process. So I just wanted to be clear on that.
Okay, and I thank you, and I know that, and I will give you credit because you have stood there before and said thank you. I appreciate that. If you don't have any further, and the commissioners don't, I'd like to go to public comment. If we can do that, please. Don't we go to public comment?
Bill McManus again. I think this is a continuing illustration of how difficult regulation can be on such a complex issue, on things that have such a huge impact throughout the county, and that somehow there's this infatuation with paperwork that it's going to be the solution. And we find and see time and time again, the paperwork lets us down. I appreciate the comments from council that their first and foremost concern is the protection of the environment. I'm not here to defend the paperwork mill. I'm here to speak out for the environment. And if they were to say that because of the screw-ups, someone left the job, someone didn't answer their email, someone didn't get this, that, or the other, there's this total breakdown of communication, that they had suspended growing and self-abated their crop until this whole thing was straightened out, I'd have a lot more respect for them. They continued growing. And we know water is one of the most important aspects of this entire industry to protect. And they had no concern for it. They had no plan for it, and everyone else is to blame for it. But it's the environment that potentially gets it in the neck. Like I said, if they decided not to grow, fine. They decided to continue growing without a good plan. How many more times do we put this county at risk by allowing this kind of behavior? Thank you.
Commission, I'm sorry to interrupt. Mr. Davies has an appointment in Sonora. May I let him go, or will the commission have any more questions for him?
I think we're okay as long as you don't need him for your rebuttal. Okay. Thank you for coming.
Thank you very much. Appreciate it.
Okay, is there any other further public comment? Okay. Then I'm going to go ahead and go to Miguel for his rebuttal.
I have none.
I have a couple comments. The first one being that the September 7th deadline is for the purposes of ensuring that the applicants demonstrate that they're capable and willing to comply with state and other regulatory programs, because we've allowed them to cultivate during the pendency of their application. So whereas the State Water Resources Control Board's purpose is to bring as many people as possible within the fold, no matter how long it takes, to prevent environmental damage, the September 7th deadline is for a different purpose. It's to have them demonstrate they're capable of complying with the law. And in this case, they didn't quite make it. And the Planning Commission and the Planning Department, didn't submit its own judgment as to the inadequacy of the NOI as of September 7th. The State Water Resources Control Board did that themselves when they supplied us with 2 separate letters saying that it was incomplete. So it just seems incontrovertible to me that as of September 7th, an incomplete application had been submitted and the deadline was just not met, and I don't see how we can really get around that.
Would you like to come up and have your,
Sure. Yeah, thank you, council. Thank you, Mr. Contreras. Just with respect to that September 7th date, I know that the board has due discretion to allow a late filing, done it in another matter that I had before you. Again, just would like to thank you all again for listening to us, giving us the opportunity to be heard. Mr. Smoot would like to thank you as well. He's been a proud and productive resident of Calaveras County for over 35 years. He's not going anywhere. This is his home. He's a licensed general contractor, and he's about as a responsible gentleman that you've seen here. And again, I would just implore this commission to give consideration to the steps he's taken, did what would be considered the best environmental practices by hiring a water technical consultant to make sure that what he was doing out on his property on Pony Way and Angels Camp was not degrading the environment, was not degrading the water supply. And to that extent, he is in compliance with 1795-165 N4. And as we sit here today, he does now have a complete application with the State Water Board, and I would beg you to grant this appeal and allow the planning department to continue to review his application further. Thank you very much for your time all.
okay? I'm going to go ahead and close the hearing, bring it back to the commission for deliberation. Let's start down there.
Okay, well, I'll start. And I start with the urgency ordinance, which does require submission to the planning department of all the necessary forms and documents to constitute a complete application to the water board. And the water board's notice of intent form, rather clearly in bold, requires that the site management plan be attached to the NOI, and it clearly was not. And so going in, we have, at least so far as the paperwork is concerned, not a complete submission by September 7th. And then when we go to the communications with the water board, which are contained in Exhibit B, there are none until June 2 of 2017, whereas the first notice from the water board that the application was incomplete or their NOI was incomplete is back in January 25th of 2017. And when I look at these emails, I don't actually see any agreement by the water board that says it's acceptable to delay sending in the SMP. What I see is advice from Mr. Davey that I'll be sending them in together. And the theory there seems to be that since he told him he'd be sending them in together and the forms other than the SMP aren't due until July of 2017, therefore it's acceptable to delay sending the SMP until July of 2017. But there isn't any clear documentation that the water board actually took that position. And so I just don't see any basis for finding compliance here. If there is compliance, and it appears there now is, it's over a year late, which I don't think is consistent with the urgency ordinance. So I think I'm compelled to vote to deny this appeal.
I really don't have anything to say on this one. I see no proof on their part that. I'm sorry. I'm just not gonna say anything. I agree with Miguel. This should be, their appeal should be denied.
And I agree as well. It seems amazing to me that there was no SMP submitted until August 1st of this year. I don't understand that. The Water Board has no September 7th deadline that I know of. So why would they ever even agree to a September 7th extension? There's no proof they did. You've got you have a couple of emails after June, but this complete blank in between when supposedly Trey Sherrill and maybe Michael Parker are agreeing to these things. There's no proof. It was late, 11 months late, at least. That's just the date on it. I don't know when it was actually submitted. It's pretty clear. It's bold. It's underlined on the form. I don't. There's just some gap in the thought process here. So I'll have to uphold the denial of the appeal.
And I also will uphold the denial of the appeal, and I just add that I found last week's case in 2016-943 to be much more difficult than this one, and I think I think the grounds stated by Commissioner Wooster and supplemented by Commissioner Bocelli are sufficient in themselves. But in any of these Water Quality Control Board negotiations between the applicant and the state, I think in some cases it could make a difference whether the applicant keeps the planning department informed or not. And here the planning department was not kept informed and very rightfully denied the application.
I think for me that the state and the county did communicate with each other. There were 2 letters saying they are not in compliance, well past whatever date the state works off of, or they wouldn't have sent out a denial letter. And it was definitely, I mean, they submitted by that September 7th, they submitted that, but then they didn't do the follow through. Tier 3 is a critical tier when we're looking at our land, our slopes, our waterways. Those are important issues for me. And where we're reaching a level tier 3, I would hope that we'd be jumping through some large hoops to get these issues addressed. And unfortunately, seeing 2 denial letters is just more than I need enough to vote with. So if evidence had been brought forward that said, look, the state sent those letters out in error, here's an email saying they made a mistake and corrected dates, that would be a different issue. But that hasn't been presented here to us today. So I also will be upholding the planning department's denial. So if I could have Miguel read the recommendation, please.
Staff
There's one
recommends,
typo.
One typo.
staff recommends that the planning commission adopt resolution.
I'm sorry, hold on one second.
All right.
He has a typo he wants corrected.
In the resolution, the second whereas clause refers to commercial cannabis registration 2016-830, should be 893.
Got it. So staff recommends that the planning commission adopt resolution 2017-077 with the correction of that typo, denying the appeal of 2016-893, thereby upholding the planning director's determination to deny this application.
Thank you. Can I get a motion?
So moved.
Second?
Second.
Okay. All in favor, say aye.
Aye.
Opposed? Motion carries 5-0. Can we take a 10-minute break, please?
This action is final unless appealed to the Board of Supervisors within 15 calendar days.
Now we'll take a 10-minute break.
Commission.
Thank
Good
you.
morning.
Thank you. Mike, are you ready, Susan? Okay. We will call the meeting back to order, and